Good morning, everyone. We'll wait about a minute for all to join here.
Who was that? Francois, was that you?
No, I'm on mute. There's a dog in the house, but it's upstairs somewhere.
Also on mute. Also on mute. Yeah.
Good to see you, Guy.
Someone's cut out my name. That wasn't me.
Yes.
It's missing the S.
Isn't it Gill? And the S. Yes. Hi, Madeline. How you well?
I think we're ready to.
I am, Guy. Good to see you again. Twice this week.
Okay, gang. Let's get orderly here. Welcome, everyone, to the third day of our symposium, 1 year on human mobility and human rights in the COVID-19 pandemic. Over these 3 days, this is the last day, we've been taking stock of the rights of persons on the move in light of the so-called 14 principles of protection for migrants, refugees, and other displaced persons. This was a document drafted by a group of international law experts, a number of them on the screen now, and now signed by more than 1,000 academics worldwide. I'm Alex Aleinikoff, director of the Zolberg Institute on Migration and Mobility at the New School, and along with my two co-organizers, Monette Zard, professor and director of the program on forced migration and health of the Mailman School of Public Health at Columbia University, and Kysel, who is clinical professor at Cornell Law School and co-directs the Asylum and Convention Against Torture Appellate Clinic. Today, we will have two sessions. The first on a paper called Refugees and the Scope for Mandatory COVID-19 Vaccination. And the second session, which will follow immediately after the first, is a closing roundtable with comments from organizers, speakers, and other members of the drafting committee, including Professor Guy Goodwin-Gill. We will end promptly at 10:30 Eastern Time this morning. So let's begin the first panel. Kristen Sandvik is a professor of legal sociology at the Faculty of Law, University of Oslo, and she's a research professor in humanitarian studies at Peace Research Institute Oslo. She'll be presenting her paper, and commenting will be Madeline Garlick, Chief of the Protection Policy and Legal Advice Section in the Division of International Protection at UNHCR in Geneva. Their complete bios are in the program materials, so I won't go through them now. Take my word for it, they're experts. They've both been allotted 10 quick minutes to make their presentations, which will leave us lots of time for Q&A. Please feel free to enter your questions in the Q&A file. We'll get to them and you can add them at any time. Kristen, nice to see you. Over to you. We look forward to your presentation.
Thank you, and thank you for having me. So I'll share my screen. Yes, so this is a social legal humanitarian studies perspective on the question of mandatory vaccinations in the context of COVID-19. So what I'm trying to do here is basically to begin a conversation. Most of my work has been on refugee resettlement and UNHCR's quest for accountability. The presentation here is not going to really parse out the specific questions regarding RSD or resettlement or even UNHCR versus the state. I'm simply interested in trying to frame some basic questions that I think needs to be addressed today. So currently we're experiencing, global contexts where there are too few vaccines, and the ones we have are unfairly distributed. And we also see that there might be the chance that types of vaccines are distributed according to the resources of the populations. So I'm Norwegian, and we have stopped the use of AstraZeneca and Johnson & Johnson, for example, to only vaccinate the population with Pfizer, and we scrapped the rest. Other places, the government is really desperate for any types of vaccines. It's really controversial. And the IFRC chief has stated that fake news about vaccines risks becoming a second pandemic. But then again, hesitancy and skepticism was really affecting the uptake for vaccination in humanitarian context long before this pandemic. And WHO has considered vaccine hesitancy and skepticism generally as a serious threat to global health before this pandemic. So this is what is at stake. It's not necessarily the question of mandated scheme or not. It's more about the future of immunization. So how should the law grapple with hesitancy, mistrust, and refusal? And this is where I'm really excited about trying to ask what the principles can do for this question. So I think it's fairly clear that refugees have the right to access COVID-19 vaccination schemes under international law. The specific rights under refugee law, humanitarian law, human rights law, and the principles as well, as you see here in principle 2. But do they have a right to refuse? And could a revised version of the principles address this dilemma? So the questions I ask would be, what is the scope for the right to refuse? What is the legality of mandatory vaccination schemes? Can vaccination be a prerequisite for access to legal protection given the prohibition on refoulement? And then simply also as a legal sociologist, I always ask, what can the law do? Quite often in the field, we see that law can't really do a lot. And I think it's important that we begin by reflecting on the limits here, and there is a political economy behind refugee vaccine hesitancy. So, refugees who do not want to get vaccinated are not necessarily anti-vaxxers. It's not necessarily caused by rationality or deviance, but very often by broader mistrust of humanitarian government. There's been medical experimentation before. There is lack of access to immunization, persecution before the pandemic, and we've also seen very poor treatment of asylum seekers and refugees during the pandemic, including virus blaming. And then there's a point which I think needs much more attention. And this is also that vaccines are no longer the same type of public health interventions as they used to be. My sense is that vaccination schemes are increasingly becoming part of a European critical infrastructure. So there's this merger between humanitarian and public health rationales. And the moment you speak about critical infrastructure, you also get the security perspective. But my thinking is first and foremost that if we don't try to understand the reasons for hesitancy or refusal, and if we don't tailor vaccination schemes towards gaining trust, new problems will arise. So this is the point of departure. I think the dilemma can be framed in a number of ways. If you see like a state, the question is if the risk of COVID-19 spread by unvaccinated asylum seekers and refugees constitute a harm to public health, which is concrete and serious enough to mandate vaccination in return for access to legal protection mechanisms. And here, there are a number of technical and practical questions about entry points, about what you do with people already in the country. What about people waiting for resettlement, which is a durable solution, not a right. But for the state, the issue is how to strike a fair balance between protecting the community and interfering in individuals' private lives. So international law has a number of instruments that details the scope for individual choice. So vaccinations require free and informed consent. There are strict criteria for derogation. International human rights law is silent on the right to refuse medical treatment, as far as I understand. But there is a torture prohibition in ICCPR Article 7. There's a right not to be subjected to medical experimentation without appropriate consent. And of course, we also have the Helsinki Declaration on Medical Research on Humans from 1964. Then we have the Oviedo Convention, which is a Council of Europe convention on human rights in biomedicine. And this convention details further, for example, that the interests of human beings should prevail over the interests of society and science, and that the interventions may only be carried out after free and informed consent. So this is clear. There is a requirement for consent, and there is a requirement to prioritize the right of the individual to choose. And there's a ban on forced enrollment in medical experimentation for historical reasons, as we all know. But then there's also intersections where governments have obligations to protect their general population against risks constituted by individuals. So in general comment number 14 on the right to health, governments are also obliged to safeguard citizens' lives by preventing and controlling disease. And this allows for certain democratic restrictions on individual vaccine choice. There's a recent decision in Vavrik and others where the Czech Republic is given the right by ECHR to restrict services for children because their parents have refused to have them vaccinated. The Oviedo Convention, Article 26, also has an exemption for protection of collective interests, and the 1984 Syracuse principles also demarcate the scope for derogations. And this is familiar to international lawyers. So restrictions need to be prescribed by law. They need to be necessary in a democratic society. The interests need to be public safety, protection of public health. It must not have disproportionate impact, and it should be voluntary unless it's really critical to prevent the concrete and serious harm. And my assumption would be that at this point in time, COVID-19 and ensuing mutations and possible future mutations and the type of societal health system collapse we've seen in a number of jurisdictions means that this pandemic passes these tests. So the claim is basically that a state may decide the mandatory scheme is needed to provide the domestic population, to protect domestic population, and that refugees and asylum seekers must be vaccinated before accessing legal processes. In a way, this is a bit of a technical claim, right? It's not imaginary, but it could be phrased in a different way. But my hope is that it illustrates the dilemmas we're faced with. So individual rights must be balanced against the type of resources that a state has command of and the type of emergency it's facing. And we know that a lot of the states that are hosting the largest refugee populations also are states which are facing economic challenges. They receive little assistance in the type of actual burden sharing from the global north, for example, and are also, it seems like, going to be very severely impacted by the third wave of COVID-19. So the rights of the states also it has to be calibrated vis-a-vis the individual. You know, there's a right to protection of sovereign borders, jurisdictional sovereignty over territory. But there are also more specific obligations, and we've really seen them come to the fore in this pandemic. So the protection of medical and bureaucratic frontline workers, for example, against infectious disease. Of course, there's also a right of health personnel not to have to engage in unethical medical interventions. For example, forcing people to have vaccinations or giving them unsafe vaccinations or vaccinations lacking in informed consent. And Ian has been concerned about the torture prohibition. So, I mean, I think it's clear that a mandate for compulsory vaccination can never amount to medical experimentation. So that's, obviously a basic test the vaccination scheme has to pass. There is a requirement for extensive scientific documentation of safety and passing these tests that we've previously been speaking about. And all this means that, these balancing acts not only have implications for the legality of mandatory vaccination schemes, but also how they organize their efforts. And I've been interested in sort of exploring UNHCR documents and WHO and policy documents circulating in terms of, what does it mean to have humanitarian vaccinations? And it's a very complex endeavor to do this well. So I think it's clear that even though your scheme is mandatory, a command and control approach is not going to work. Globally, states have very different approaches to sanctions if you don't comply with mandatory schemes. but they generally seem to be quite unsuccessful. So states must give adequate financial attention, capacity, logistical attention, medical attention to non-coercive acceptance-driving aspects of vaccinations programs, for example. They must be appropriately organized. It's important that vaccination programs for refugees and asylum seekers are not of lesser quality. There must be safeguards against abusive applications of programs. If there are side effects, for example, there must be compensation and healthcare available. Information is obviously key. It must be adequate, appropriate, and accessible. And important here is also that if you want to have a mandatory scheme, you have to explain why it's mandatory and the link between mandating vaccinations and the rights and obligations of the person you're vaccinating. And this, of course, needs to be provided in a language and technologically and culturally appropriate format that all recipients will understand and can access. And this is not, it doesn't come for free. It takes time and an attention. And the argument is simply that, even if you have a legal basis for a mandatory vaccination scheme, which I think countries might have, and UNHCR might have to indirectly engage with, we still have challenges. So yes, mandated vaccination is probably permitted. The right to health for refugees does not include the right to refuse COVID-19 vaccination if certain requirements are fulfilled by the states. But then we need to pay more attention to have this mandated vaccine scheme might be meaningfully coupled with non-refoulement obligation, for example. And then the threshold for making a vaccination scheme mandatory is, of course, quite high. But in reality, neither states or UNHCR are faced with many options if people refuse to take these vaccines. So states can prefoul. Detaining or quarantining people who refuse is going to be very costly. I already spoke about the political economy of hosting large populations, and also might engender broader problems with communal acceptability. If you start detaining people who want to get vaccinated, it's not likely that this entices more people to come forward. And of course, letting people disappear in the crowd, which is what very often happens, defies emergency health objectives. So even with the law on your side, authorities, humanitarian staff, UNHCR will be left to persuade and nudge and cajole. So force is essentially ineffective here. And I'm concerned that applying any type of force or coercion might actually, mean 2 steps back instead of 1 step forward, and create more problems for vaccination schemes, and then particularly child immunization, which would be very unfortunate. I think my 10 minutes are up. I hope it wasn't too quick. Thank you.
Thank you very much, Kristen. Interesting comments. And in fact, there was a question about whether you're willing to have your slides made available to participants. If we could host them, people would like to see them and have them. That's possible. Okay, Madeline, over to you for comment.
Thank you very much, Alex. And really thanks to the conveners of the symposium and all of those who are joining us over these 3 days to discuss these really crucial global issues around human mobility, human rights, and the pandemic, which are, I think, accurately characterized really as defining issues in many ways of our current moment in history. I'd also like to thank Kristen for her very thought-provoking paper. And it's indeed going to be interesting to see what participants have by way of comments and interventions in response. In responding from my side, one first crucial thing I should make clear is that UNHCR does not require refugees and asylum seekers and other persons of concern to undergo COVID-19 vaccination before accessing any of its protection, assistance, or other services, be it registration, refugee status determination, advice, material assistance, healthcare it facilitates in many parts of the world, or anything else. And much less does it penalize those who might be disinclined to have a vaccine. This, of course, would be the inverse of HCR's goal and mandate. And if it's been alleged or reported anywhere in the world, I'd be very glad to hear of it as soon as possible. Thank you. So the idea of compulsory vaccination isn't actually anywhere in discussion at the moment or in view within UNHCR. And we're not aware of any state that at the moment is making it mandatory for refugees or migrants or is planning to. It's nonetheless an important conversation that needs to be had indeed, because we are all going to need to see how the situation evolves in the future, of course. If it were to be proposed for asylum seekers or migrants on the basis of their asylum seeking or irregular migratory status, this would clearly be highly problematic, as well as counterproductive in terms of public health protection. And if it is to be proposed by any states as mandatory for all those in the territory without discrimination, then I think we would hope from UNHCR's side and expect that there would be many opportunities to seek to influence the way in which this could be done, to ensure that it could be carried out in a manner which is compliant with rights and some of the safeguards which Kristen has rightly highlighted. There are, of course, we know, ongoing reflections amongst states about the introduction of so-called vaccine passports as a basis for permission to travel or to do other things. And this came up recently in discussions at UN level in the context of the UN Migration Network, charged with supporting the implementation of the Global Migration Compact, where network members, including HCR, have agreed to urge extreme caution and to underline to states the many potential concerns around such a scheme, which, as WHO rightly said, should not be called a vaccine passport, because these will not be ID or travel documents, rather simply certifications of vaccinations, as currently foreseen. So the title of this panel, I noted in preparing today, I saw in the Save the Date message, was access to vaccines, which of course is not the topic which Krista's paper has addressed. But I should say, speaking frankly from UNHCR's principled legal, policy and operational perspective, working with states and millions of displaced and stateless people worldwide at the moment, securing access for refugees, asylum seekers, returnees, stateless and internally displaced persons is the really immediate and larger challenge in front of us now. The good news is that many refugee hosting countries with which HCR is engaging are agreeing to include refugees as well as migrants in their national vaccination schemes. Some of them, interestingly, are ready to do so on a low-key, non-public basis. They don't want it to be known widely in order to avoid any negative political repercussions. There are a few limited exceptions, but it may be that these can be overcome as vaccines become more available and as it becomes more evident that there are benefits from making such things universally available. The less good news, of course, is that slow vaccine rollouts in many countries are affecting refugees and migrants as they are their host communities, and that many low and middle income countries simply can't secure the large-scale deliveries of the vaccines that they need, given, as we know, the fierce competition and the fact that many of the richer countries have managed to obtain the lion's share. So seeking to secure access to vaccines for persons of concern in the first place, alongside equitable access to healthcare, preventative measures and equipment, is something we are strongly advocating for, based, amongst other things, on the right of all to the enjoyment of the highest attainable standards of physical and mental health, which are provided for under Article 12 of the International Covenant on Economic, Social and Cultural Rights. HCR is strongly supporting in that the principle of free and informed consent to vaccines, and are not contemplating at this stage any idea of supporting the idea of mandatory vaccine programs run by states, nor the idea that vaccines would be a precondition for access to asylum procedures or other measures of protection or assistance. If, nevertheless, vaccines were to become a mandatory precondition for entry at states' borders in some cases, one would have to look very carefully at how such a measure were to be formulated and implemented in order to assess its lawfulness, given states' sovereign right to regulate admission to their territory, amongst other things. Kristen has rightly pointed out, of course, the crucial principle of non-refoulement, which applies, amongst other things, of course, to require states to refrain from denying entry at their frontiers, where failing to do so would expose people directly or indirectly to the risk of being returned to persecution or torture, inhuman or degrading treatment or punishment. However, if there's no immediate threat on the other side of the border, it may be difficult to make a case that the non-refoulement principle precludes a vaccine requirement as a precondition for admission to the territory in circumstances where it could be seen to be crucial for safeguarding public health. If access to territory might be required to avoid the risk of refoulement, there is also scope for us to encourage states to take alternative measures to protect public health, including testing, quarantine, or monitoring as part of admission to the territory. So from where HCR stands at the moment, the first goal would be to advocate for a system that can manage public health risks whilst ensuring respect for rights, including the right to seek asylum and enjoy asylum. We'd agree that ultimately a mandatory vaccination scheme, if introduced, would absolutely need to respect very important key safeguards in order to be lawful, including being shown to be proportionate, necessary, and reasonable in the circumstances. It would also need to be subject to exceptions where needed in individual cases. For example, if people were allergic or had other medical conditions which could preclude their access to a particular vaccine. This being said, placing great emphasis on the right of refugees and migrants to refuse vaccines could carry some risks, and I'll just mention two. I think firstly, we do run the risk of giving or being perceived to give credence to the idea that vaccines are dangers from which refugees and migrants need to be protected. And in an environment where we do see worrying levels of misinformation about vaccines, this does create the risk of hampering a clear understanding of what priorities need to be addressed to ensure optimal protection for refugees and migrants' rights, health, and well-being. And I think linked to this, any suggestion that administering vaccines which have received WHO and national and regional approval worldwide could amount to medical experimentation. I don't claim to be a medical expert, but I think even if no one can really say that they are 100% safe in all circumstances, I think the programs now rolling them out to millions of people daily are no longer experimental in character. As a second point, I think we run the risk of feeding unfounded perceptions that migrants and refugees are or could contribute to public health threats. We've all, of course, taken issue with some of the stigma and xenophobic rhetoric that has painted them in some countries and contexts as the source of the virus or of other threats. But if the medical information is correct, many experts, of course, believe that widespread vaccination will increase the safety of many communities. And there is limited protection value, I think, therefore, in encouraging the idea that migrants and refugees will and need to refrain from being vaccinated. Legal arguments that create the risk of reducing political or public support for refugees and migrants do create the risk of undermining rather than reinforcing access to respect for their rights. So I think in broad terms, what we as HCR have seen is clearly that COVID-19's impacts have profoundly and disproportionately impacted upon refugees, asylum seekers, returnees, stateless persons, and internally displaced people, as well as migrants in irregular situations in many contexts. We've seen very significant health effects, including increased risks of infection, as well as lack of access to preventative measures or treatment in many cases, simply because the systems for healthcare in many host countries are significantly overloaded, bearing in mind, of course, that some 80% of the world's refugees are hosted in low and middle income countries. In this context, we've been seeking to encourage such states to look at including displaced stateless persons as well as migrants in national health services. And positively, we do get a positive response in many cases, but such states are making it very clear that what they expect is greater international support and responsibility sharing in order to ensure that their own populations can also get access to the kind of healthcare that we are advocating for refugees and other persons of concern. We've also seen, of course, very significant increases in a number of protection risks. And in guidance we issued in March last year, HCR has acknowledged, indeed, that in a public health emergency, states may take lawful measures that could limit the enjoyment of certain rights and derogations in some circumstances. But we've needed to underline very firmly in many circumstances that lawful measures to limit entry at borders, for example, may not prevent people from seeking asylum, nor expose them to the risk of refoulement, bearing in mind this is a non-derogable right and a norm of customary international law. We still nevertheless see many countries that are imposing restrictions on entry, some of whom are making exceptions for asylum seekers and refugees, but not all. So the protection risks we see across the board are very significant. This is added, of course, also to other impacts, including horrifying rises in gender-based violence, impacting for many displaced and stateless people in particular, where measures have led to lockdowns, and material and economic impacts. So,
Madeline, can I ask you to sum up now?
Yes, of course. Thanks, Alex, of course. So in conclusion, indeed, I think as part of our core mandate responsibility, HCR is going to continue to focus on pressing for access to healthcare, including to vaccines. But we're going to need to make sure that other elements are in place to ensure indeed that trust can be built up, as Kristen has rightly highlighted as a critical element in this respect. Firewalls can be put in place to ensure people don't face increased risks of deportation if they approach health authorities, and that the principle of free and informed consent is upheld, bearing in mind there are other ways to ensure indeed that health can be safeguarded in many cases. So thank you very much. We really appreciate the opportunity, and we look forward then to the discussion. Thank you.
Thanks very much. Thanks to both of you. These are really interesting conversations because, remarks, because it showed really the complexity of the issue, and their arguments on both sides that make a human rights analysis really quite difficult and actually quite interesting, given the rights really on both sides of these debates here. I have wait for some more questions in the text. I have a question that is similar to Elspeth Giles' question that's been put up here. One question for Kristen and one for Madeline. Kristen, is there a difference in your analysis between resettlement programs and asylum seekers who arrive spontaneously at the border? Might there be more justification for a vaccination requirement in the former than the latter? And Madeline, for you were saying that there might be alternatives to a vaccination requirement like testing or quarantining, but I wonder why those measures aren't as intrusive and sometimes more intrusive than simply getting a jab. So I'm wondering why one is an alternative to the other, why they're not judged by equal standards. Kristen, do you want to go first?
Yeah, with the case with resettlement versus refugee status determination, IOM, there are already requirements for health checks and tests that you need to take as a traveler. So that would probably just be slotted into existing programs and then probably be less problematic. Even though you would not need this to enter a new country, you might need it to travel. And I do think that for refugees and asylum seekers, the digital vaccine passports or certificates. I mean, there's something going on with the merger of digital identity here with public health screenings, and that I think we need to take care of thinking about. So there's an example of I'll make this quick. There's an example of a religious group from Burundi refusing to go through biometric refugee registration in Rwanda and then returning home. I mean, I do think that we need to take hesitancy and refusals quite seriously. And I mean, I completely agree with Madeline's points about, how do we think about this without making this group more suspect or without being patronizing? I'd be very concerned about quarantining. We have quarantine hotels in a number of countries in Europe. These are jurisdictions that should be fit for purpose. They're not. They're really not working out well. It's extremely costly, and it's probably constitutional violations en masse. And I can't really imagine how this would look in a country where people were detained at the border. So I'd be concerned about quarantines. Thanks.
Madeline?
Yes, thank you, Alex. No, very, very relevant points. On resettlement, indeed, as Kristen has said, there's health checks are needed for resettlement at the moment, and often this is to ensure that people can get the appropriate treatment they need, which I think we'd all agree is an important matter for people who might be suffering from conditions. But I'm bearing in mind also resettlement one of the priority categories for resettlement for UNHCR is people with specific medical needs, and quite often it's people who are specifically being taken to a country which is able to care for their health needs that is the basis for that resettlement. So I don't think we should necessarily always see this as being a problematic aspect. I am not aware at the moment that there is a mandatory requirement for vaccination for resettlement departure in any instance. I say that with caution because, of course, this is all evolving quickly. But one of the reasons why that hasn't been the case until now, of course, is that many of the countries from which resettlement is taking place are countries which are precisely those that can't secure access to the vaccines. HCR is trying to support that, as is, of course, the COVAX facility and others. And I know that's been at the top of the agenda for the High Commissioner's discussions with a number of states in recent times. So that might well come about as a requirement indeed for travel. On quarantine and testing, I fully acknowledge this is indeed also something that needs to be handled with care. I raised this, however, in the context of some of the discussions we've had about refusal of entry altogether at the border, where part of our messaging has been that states do not need to close their borders comprehensively, leave people stranded in land border zones, or even worse, leave ships drifting for weeks and months on end, as we've seen in Asia in recent months. On the pretext that this is due to COVID-19, we've rather suggested that one should be looking at quarantine. And I mean quarantine, I don't mean quarantine masked as detention, because of course there's some very important safeguards around limits on freedom of movement that need to be respected in these circumstances. This also has to comply with necessity, proportionality, and be reasonable in the circumstances. So just to make clear, I'm not proposing any of these things as the panacea, but they are options that need to be considered. And if people do see them as something that they're ready to undergo in order to gain access to territory and safety, then it's certainly something we need to be looking at. Thanks.
Thanks. Let's go to a question here from Catherine McCann. When a state is determining whether they will mandate vaccination for refugee and asylum seekers as a requirement for receiving support and services, should that decision be made with reflection to requirements made of the general population of the state? For example, if the state does not mandate citizens receive vaccination, can it legally or ethically mandate refugees and asylum seekers be vaccinated? Kristen?
Right, so I think that, I mean, that's, you know, the obvious question, right? If you're not forcing your own population to undergo vaccinations, why would you force or try to force refugees and asylum seekers? My assumption would be that as long as you control access to the territory and it's not an undue burden, and the fact that, you know, this population might come with a different mutation than the one that's so far been present on the territory. For COVID-19, I think this is possible. I think there's so many interesting knowledge politics here, right? So viruses mutate. I mean, that's what they do. I think in the context of this pandemic, each new mutation has been sort of attributed a specific geographic origin, which is fairly often deeply racialized. And I think that might contribute to a government's willingness to force certain populations to have vaccines. So we started out with the British mutation, no offense, and then we went to the Brazilian or South African, and now it's the Indian mutation, which everyone is afraid of, right? But this suggests that you can be concerned about new mutations entering your territory.
Okay. Madeline, what do you think about this discrimination question?
Yeah, thank you. No, I think the short answer to Catherine's question is no. I think under no circumstances would it be legitimate to require vaccination exclusively on the basis of status as an asylum seeker or a migrant or an irregular migrant. If people are already in the territory, then public health would dictate that if it's necessary to vaccinate people, you vaccinate all of them. You or at least make available vaccines to all of them, not based on their migratory status. Similarly, if people are arriving at the border of the territory, and as Kristen's rightly said, indeed, there are some new mutations. Some states are concerned about that and how they're going to manage that. But that logically requires that you apply the same requirements to everyone arriving, and not because whether distinguishing on the basis that they might have a visa or not, or that they might belong to a certain origin or not. discrimination could reasonably be foreseen on the basis of the country from which you are coming if you've been exposed to the risk of a certain mutation, but not on the basis of your status. I think this is clear. Thank you.
Which actually is interesting. The US, original US ban from China and from Europe didn't apply based on nationality, but rather people who had been in those areas in the previous 2 weeks. Of course, there were exceptions for close family members and things like that. Okay, another question from Judith Gleason. First, praising you, Jennifer, for your, I'm sorry. I'm not sure what that refers to. Anyway, I'm sorry, that's the posting of the slides. Right, okay. The balance between the right under EU law to physical and moral integrity and the right to society to protect its citizens against carriers of the virus interests me at a time when the US court is revisiting Roe versus Wade. Does the panel think that there is a risk of public health measures leaking back into other human rights issues with less obviously positive consequences? Any thoughts on that, panel? Kristen, for you.
I mean, I think the detour is via critical infrastructure. So the moment your vaccine program is a question of critical infrastructure more than a choice or personal choice or government mandated schemes, you pull in the security legislation, and then you start talking about national security in a very different way. And then public health becomes securitized in a different way. And then we're sort of almost back to the parallel problems that we've had after the global war on terror. So yes, I'm deeply concerned, and I'm also specifically concerned about the certificates, and also kind of the interests that are behind a digital industry of these certificates, and interests that are behind sort of massive vaccination schemes covering new mutations for years to come. So I think for the question that we're discussing here today, when the pandemic is declared to be over, is of vital significance. You know, we can't have this in 5 years' time. The pandemic has to be declared to be over, you know, the minute medical knowledge tells us that it's over. But in reality, it will be over when the political context and those discussions decided it's over.
Yeah, it's odd to think of pandemics as socially constructed, but that's what you're suggesting here, Kristen. Madeline, 1 minute left to you, and then we'll move on to the next panel.
Okay, yes, thanks. Perhaps just, I think indeed, following on from the question, really any basis on which it's proposed to derogate from rights needs to be handled with extreme care. And indeed, as Kristen has said, there's very clear constraints in international law for when rights can be derogated from. This needs to be respect principles of necessity, proportionality, and non-discrimination. And there's some rights which can never be derogated from, and refoulement is, protection from refoulement is one of those. It was very interesting for us to see last year that some 31 states derogated from different international and regional human rights treaties over the course of the first part of 2020. But very positively, what we've seen is that a very significant number of those have since lifted those derogations. And this, I think, shows that the international human rights system is indeed geared to deal with threats such as this. But one needs to be continually vigilant about it. And I think it is indeed very clear that public health, simply invoking public health, will not of itself justify far-reaching measures on an indefinite basis. Thanks.
Thanks so much, and thanks to the panel for a really interesting discussion. And I think close listeners will notice that there really were some differences between these speakers on a number of these issues that I think leaves us with much food for thought as we try to tease that out in days ahead. Really terrific. Thank you so much, both of you, and I hope you stick around for our concluding presentation. I turn over now to my co-organizer, Ian Kysel.
Thanks so much, Alex, and thanks to Kristen and Madeline for that great first discussion. Welcome all to this, our final roundtable in this symposium. Over the last few days, we've reflected both on how the rights of migrants, including refugees, have fared in the pandemic, and we've done that through looking at those rights in connection with some consequential issues facing states in relation to mobility at this point, and really throughout the whole pandemic. Freedom of movement, the right to health more broadly, the use of digital technologies in the context of the pandemic, and this morning, vaccination. So in this closing roundtable, we wanted to open out a bit We're joined, in addition to the co-conveners of the symposium, Monette and Alex and I, we're joined by two of our colleagues and co-authors of the 14 Principles, Professor Goodwin-Gill, who's a professor at the Calder Center for International Refugee Law at the University of New South Wales, an emeritus fellow of All Souls College, Oxford, emeritus professor of international refugee law, and an honorary associate of the Oxford's Refugee Studies Center, and Francois Crépeau, full professor and the Hans and Tamar Oppenheimer Chair in Public International Law at the Faculty of Law at McGill University. Full bios you'll see are in the chat. In order to set the stage and start off what will otherwise be a discussion among all six of us, we've asked Guy to share a few minutes of reflections on the greatest rights challenges faced by migrants, refugees, and displaced persons in the last year as it relates to our 14 principles, but also the overarching theme of the last few days, how people in the context of mobility have been impacted by the pandemic and the new and emerging ways in which the rights of these populations might be challenged going forward. So we'll just move right after that right into discussion. And I hope, in addition to reflecting on the panels and this theme, that we might think about something of a path forward, whether for the 14 principles. So should there be a 14 principles 2.0, as Alex queried at the outset of the symposium, or for the protection of the rights of migrants, refugees, or other displaced persons. So if even as we've not exited this pandemic, what does COVID tell us about the proverbial next crisis? But thank you all for joining us, and thank you, Francois and Guy, for joining us at this roundtable. Guy, let me give you the floor.
Thank you very much, Ian. Thank you. Within the context of the 14 principles and the goal of this symposium, as you've heard, I've been asked to provide a few minutes of reflection on the greatest human rights challenges faced by migrants, refugees, and the displaced in the last year. As expected, things have got worse, and it will take time to re-establish, or even to establish for the first time, protection on a sure footing. Research undertaken by the World Health Organization and reported in The Guardian on the 7th of May indicated, for example, more than 70% of 104 government vaccination plans excluded migrants. Most did not include refugees and asylum seekers, while 11.8 million internally displaced were also omitted. On the general question, I have just 3 points that I want to make briefly. First, on the one hand, COVID-19 has proven to be a useful distraction for governments which want to allow ill treatment and abuse to continue at borders and on the high seas. On the other hand, it's proven to be a useful vehicle for greater ostensible control over migrant and refugee populations. For example, on the 14th of May, Australia enacted new legislation with no advance notice and no consultation. New legislation authorizing the indefinite detention of certain individuals who could not be removed either on refugee grounds or because there was no country able and willing to accept them. Ostensibly, this was done in the interest and with the aim of strengthening the implementation of Australia's non-refoulement obligations. The very same week, the government's budget included huge expenditure on detention facilities. Secondly, as Chiloka Bayani pointed out on Tuesday, while there have been very few formal derogations from human rights treaties, there have been many derogations in fact. This is important because the process of derogation implies certain safeguards. The absence of formal derogation means that such safeguards are missing or diluted. Oversight, monitoring, and the judicial review of police measures, among others, are absent. There are no or fewer remedies for those detained, for example, in conditions that expose them to the risk of infection. Thirdly, controls over movement, both internally and externally, have been ramped up. Even though many states have not imposed a barrier on access to protection procedures, the means for getting to those procedures have been curtailed. Moreover, as we've also heard yesterday, technology is already there at the border and beyond, with drones now engaging in aerial maritime surveillance, but with little oversight. And at the level of individual decision-making, we could perhaps be moving from a rules-based order to one in which the rule is generated directly by an algorithm, not by human beings. and applied in a context where the lived experience of the refugee and migrant are not front and center as they should be. To what extent, without being pushed, will governments be ready to give up what to them appear to be useful and productive controls, either generally or specifically? In Australia, sorry, it's where I'm currently based, the government has denied the right of citizens to return, ostensibly in the interest of protecting the wider community from the risk of infection. It now treats the citizen as the other, as it does the refugee and the migrant. What is to be done when a government can change the law at will with no constitutional control or oversight? The answers are not obvious, nor are they simple. Risk is part of living, and we need to learn how to live with it. Governments have the power to control, but we have the power to react and to resist across many fields. Above all, we have the information directly from those impacted by COVID-19 restrictions. These stories, this narrative, must go on being told, and told in litigation, told in policy meetings, told in legislative discussions, and above all, told in our conversations with people at large. This means also that we must be prepared to identify the border police and the prosecutor individually responsible for pushbacks and criminal proceedings. It means continuing to pressure state authorities which refuse disembarkation and those that will not support it with appropriate guarantees. It means combating the indifference, aided perhaps by the death toll due to COVID-19, combating the indifference whether people live or die, and the woeful lack of basic decency and common humanity. On Monday, I was speaking at another conference, and I quoted something that Antoine de Saint-Exupéry had put in his book, Flight to Arras, Pilote de Guerre, published in 1942. He wrote, "Each of us is responsible for all of us. Each of us is alone responsible. Each of us is alone responsible for all of us." More of the same then. Thank you.
Thank you so much, Guy, for those remarks, which I think create a wonderful playing field for exploring some of the most troubling themes that we've heard in the last 3 days. And I want to invite just discussion among the roundtable participants, either responses to anything that Guy has raised, or perhaps we turn first to, or in addition, perhaps if there were reflections on what the path forward might be for the 14 principles or out of this symposium. Is there something that comes from this? Francois, Alex, Monette, I welcome your intervention.
I could start.
Thank you.
Over the past year, in looking at how governments have handled the pandemic and the situation of migrants and refugees, I was struck by the alignment of our 14 principles with the Global Compact. And I was also struck in the past 3 days how little the Global Compact was mentioned. It was mentioned, but it was mentioned really in passing without any. And I think that's quite telling. The Global Compact has been negotiated by experts, civil servants, international civil servants as well, states, but states representative at a civil servant level. These people knew what they were talking about. And they came up with a document which was surprisingly good, not perfect by far, but surprisingly good. It's been endorsed by politicians, but there's the nagging feeling that they never intend to implement it in any way. Actually, they've been doing the exact contrary of much of what is in the Global Compact. And this is, I think, the key issue that we have. Migrants are objects of migration policies. Migrants are not participating in the discussions. Migrants are not bringing a reality check to migration policies. And so what politicians are, thriving on, which is, stereotypes and myths, goes on, and we citizens, generally, we don't care. You know, globally, we don't care. Citizens don't care about migrants. This is not the first preoccupation. Other preoccupations are more important: taxes, schools, healthcare for us, etc. And so politicians have been able to do almost whatever they wanted. We've just had examples by Guy about Australia without a constitutional constraint. So the fundamental issue is that migrants need to have a voice. So many organizations can carry their voice in the debates about health policies, but migration policies generally. Unions should play a much bigger role than they do at present, but we are in a deunionization movement. Certainly courts, human rights commissions are playing a role, but it's late in the day, it takes years, it takes money, and migrants are not willing to stick their neck out protesting, etc., if it can threaten their migration project. So it's difficult. Migrants will not use, you know, the complaint mechanisms. We know that almost everywhere. Their voice is silenced because of fear of being detected, detained, and deported. And so I think in the end, we need to work for them, as Guy suggested at the end. We are responsible also for them, but they will need to have their own voice, and we need to carry that voice. And so we collectively, but migrants need to be heard. And I think that if we think long-term, not immediately, long-term, migrants need the right to vote. We've distributed economic and social rights according to residence and not nationality. The right to vote is not very different, and it's the principal mean of obtaining, of implementing economic and social rights. It's fighting for them. I mean, rights were not given on a silver plate to women, to indigenous peoples, to the LGBTQ plus community, to detainees, to persons with disabilities. They fought for them. Migrants have huge agency. But when I'm talking about migrants, I'm talking about migrants who have a precarious status for sure, in, you know, asylum seekers and temporary workers and undocumented workers. But those migrants will not speak up if that threatens so how do we provide them with a voice? In the end, it's the right to vote. And that's, I think, is the ultimate objective based on residence, because that will give them a voice, and suddenly politicians will listen, as they have listened to women over time and the LGBTQ community and indigenous peoples. The right to vote gives you a tool in the political debate, which is completely absent. Thank God this crisis has allowed some realizations. You know, health workers were given the nickname guardian angels in Quebec. Agricultural workers were deemed essential. So stereotypes, myths are being deconstructed very slowly, but until migrants themselves have a voice in the debate and bring their reality to the other people in society, like the other groups have done in the past, it will be difficult to fight stereotypes and fight the politicians that use them.
Ian, if I could come in, just to Francois, if we have to wait for immigrants to have the right to vote to protect immigrant rights, we're in trouble, because that's not happening soon. And I think there are lots of other ways that immigrants can have voices through protest and demonstration, the way they have in the US and other places, without necessarily having the right to vote. But I agree that the immigrant voice here is crucial. A couple of just sort of random thoughts. And this is I guess the converse, if that's the right word, of Guy's last statement, that we are all responsible for each other. Each one of us is responsible for all. And I hear this statement sometimes said that, no one is safe unless everyone is safe, right? That no, we have to cure it for everyone. I just think that's wrong. I think states have found out that they can make themselves safe whether or not the rest of the world is safe. The fact that COVID cases are really on a very, very rapid decline in the US while skyrocketing in India shows this is possible. And we've put a ban on now on travel from India. It's like having gated communities. There are lots of ways that rich people in rich states protect themselves from others. So this kind of almost Panglossian claim that, this moral claim that until we've cured everything, we're not safe. It's just not right. I don't think it's right. Maybe others disagree with me, but people have a way of protecting themselves from that. And it links for me in some way with Kristen's really interesting comment about when we declare the pandemic over. Now, what I heard her say was the scientists may say it before the politicians because the politicians want to keep in place the kinds of restrictions that Guy has talked about and others have talked about over the course of these 3 days. This became a very convenient way to adopt rules. This was certainly true in the United States, where a new procedure called expulsion was put in place at the southwest border. Hundreds of thousands of people have been expelled with no process whatsoever through a CDC order, which is pretty much illegal, probably will be eventually determined to be illegal in the courts, but nonetheless it stands. President Biden came in and left the order in place. So there's all sorts of reasons why, just like with 9/11, these kinds of securitization measures will continue beyond the scientific necessity. On the other hand, in the United States, the other problem was people thinking the pandemic never happened, right? We had people who wouldn't wear masks, who wouldn't socially distance. So the social construction of pandemics can run both ways. It becomes a political discussion about pandemic, which makes it trickier to work. I think the strategy has to be really on the 14 principles, whether we need to expand them or not. And there were so many issues raised that we hadn't thought about that are really interesting issues that should somehow find their way into them. I think there's a demand that these measures be temporary, whatever measures are put in place really be temporary, and try to monitor that as best we can, lest we're stuck with them forever. Anyway, just a number of random thoughts.
If I could just pick up on some of those comments, and as you all know, I sit in a public health school, and so I think just picking up on Alex's comment that we can safeguard ourselves without thinking about the rest of the globe. I think that protection is illusory. I think the jury's still out on whether the mass vaccination campaign within the US, within Europe, is really going to provide the level of protection that the population is seeking. And I think the reality is we live in a globalized world. We think we can shut borders, and we're pretty effective at doing it, but our goods, our services, and our people still cross borders, even in the face of these closures that we think states have implemented. So, I do think that from a public health perspective, you need a global approach. And I think there is going to be a rude awakening as people, go on holidays, and as health workers go back and forth, and as families resume their connections across the globe. I think the shortcomings of an approach that doesn't see the need for a global approach to vaccination is going to quickly become apparent. And it does, for me, raise one of the other broader points, which is, I think what this pandemic has really signaled, which is truly troubling on a macro level, is the collapse in some ways of multilateralism. We did have this thing called the International Health Regulations that was supposed to provide for a coordinated multilateral approach to pandemic control. And what we saw was an embrace of unilateral measures, and hugely supported by public opinion. And I think, beyond the sort of need to look to the future and think about how we reconstruct and make the case for a multilateral approach, I think the other big challenge that we face as human rights sort of advocates and scholars is the really troubling fact that people have embraced many of these restrictions on their own civil liberties, on the civil liberties of citizens, as Guy pointed out, and feel that this is what is necessary to keep them safe. And so to me, that is a huge challenge that the human rights movement faces. How do we make the case that a more globalized approach is necessary? And perhaps the final thing that I wanted to say, again, it's from my perch in a human rights school, is I think that we need to see much more engagement by public health sort of practitioners and scholars with folks working on migration. I think the fact that the CDC has allowed itself to be co-opted into keeping, Title 42, the expulsion order, in place is truly troubling for the future of public health in the United States and potentially globally, because the CDC had credentials globally. And we see migration policies being made now, I think, in the absence of real engagement by public health people who are generally cautious. They're not engaging with the reality that people cross borders all the time. And so we need mobility competent public health systems that adapt and that work with the reality of what I think we should aspire to have, which is a reconnected world. So I do think those are some challenges I see ahead, maybe not directly for the 14 principles, but for the way we do our work together.
Thanks, Monette. And I'm certainly open to anyone jumping back in. I think I am interested in sort of, turning some of these themes back, particularly to the principles and to this collaboration, the symposium. Are there particular ways that that we could move forward together to provide some kind of a tool based in human rights that would address some of these challenges? And certainly, I'm struck by a number of the paths forward, not necessarily fundamentally starting from the perspective of clarification of the law, the utility of soft law, right? It's about political campaigns. It's about, certain voting is eventually a legal tool, but how do we get to that point? And I wonder if there are particular, Alex mentioned this question of a number of gaps in the principles, but is there something that we could do either as drafters or in conjunction with those who have endorsed the principles to help energize this movement? And I also want to draw everyone's attention to the one question that's coming in the Q&A, which I think is a very appropriate one, which is following on to the invitations by Guy and Francois for the involvement of migrants, the sharing of stories. Alex raised this as well, but a particular question of how can we support bringing immigrants themselves to the table, recognizing some of the challenges, Francois, that you identified? Are there particular avenues that if we do take this forward, that we could commit to that would engage that problematic?
I mean, following what Monette just said rightly, migration policies are often made by migration policy people, period, often with orders from up above. And in many countries, they're the only ones who are authorized to speak about migration policies, when migration policies should be discussed by a much wider array of specialists. If a migrant kid doesn't do well at school, it's a migration issue. If a migrant kid comes to the hospital, it's a migration issue. No, it's a public health issue. It's an education issue. And we should have specialists of all these fields discussing migration policies and why this or that. For example, the detention policies have a huge impact on the right to education. And yet, education specialists are never consulted about detention policies. And so I think we need to have a much wider array of civil servants and other actors in society discussing these migration policies. It's not what governments want, for sure, but we need to push for that.
I agree. I think the 14 principles have value. They are a base from which to take many initiatives forward. We can use them. I think they're simple enough to present at schools, amongst other things, as a basis for discussion, a basis for taking it forward. And I think a basis also for judging the actions of states, of governments throughout the world. I think that we can do that. I mean, you've mentioned there are holes, there are opportunities that have been missed. What are they? I don't know. Could you list them for me, Alex? What are the gaps in the 14 principles that you have heard of?
Well, maybe these are applications, but the issues of biosurveillance, I'm not certain we've covered fully, and the issue of forced vaccination, which Kristen just presented a paper on. Would be two at least.
Okay, the 16 principles.
My
But
point,
only,
I mean, I think the more important thing is the mobilization of the principles we have, and the recognition that things. Although Madeline did mention some states taking back derogations, there's been some reducing of the restrictions. Overall, the human rights situation does not seem to have improved, and we have every reason to think it will either stay bad or get worse, given the examples you've given from Australia and the fact in the US that things have not radically changed on our border. So I think the main work is really taking what we've got and trying to push it forward in the best way. We kind of, we wrote a document, 1,000 people signed it, and we put it out there, and it's been cited, and NGOs know about it. The Secretary General has mentioned it in a report, and et cetera, but exactly how to mobilize them further, I think, is the work ahead.
Ian, may I come in?
Please,
Madeline. Yeah, just very briefly. Oh, and really thank you everyone for your remarks here. Just a couple of quick things. Firstly, I think the point that's being made about seeking to reflect the voices and the perspectives of migrants and refugees is a really crucial one. And perhaps that could be part of the framing of any new issuance of the principles also. I'm sure there's ways we should make sure we do that. You mentioned the global compacts also. Indeed, these should be applicable and should be relevant here. And amongst other things, the global compact on refugees emphasizes the crucial importance of a multi-stakeholder approach, including the voices of refugees in deciding what needs to be done to address their challenges. Perhaps as an additional suggestion for the next version of the principles or a new presentation thereof, in UNHCR, we've been noting that there's a need really to look at ways we can better ensure we take account of lessons learned. Some of our public health colleagues have been talking about what we have experienced through other pandemics or other national epidemics, Ebola, Zika, and others. And there's a sense that we really do need to learn the lessons from the past year and to try and take them into account in how we fine-tune what is going to be done over the coming year with COVID, but also possible situations in future that could present themselves as public health emergencies. So perhaps that's something also as a framing message that 1 year on, a new iteration of the principles could also include. Thank you. Over.
Thanks so much, Madeline. And Kristen, I see that you have your hand up as well. Please feel free to come in, and then Francois, I'll go to you next.
Thank you. Just to the point on the principles, I think it's 8 and 9 that deals with the right to protect, no, it's 9 and 10, right to information and protection of privacy. I'm just thinking about what Guy says about the algorithms and sort of how everything is becoming about techno-legal infrastructure. And I do think that we need to try to conceptualize risk in a different way. So refugees and migrants now have to be digitally visible to gain protection. The conflation between legal and digital identity. You're only able to be protected if you give away all your information. So your digital body becomes quite significant, and it can also put you at enormous risk. And while I think that Primes is a fascinating attempt at managing global refugee flows, it also creates a lot of new challenges for how people can be empowered to protect their own data, but also the risks they're subjected to. And also, if you look at the risks for refugee lawyers, for example, who might now be new threats to their own clients because of the type of information they cobble and gather. So I do think, that's one thing, and it's relevant for many phases of the displacement cycle, basically from cradle to grave. And in conjunction with the digital, there's something very concerning about DNA happening. I understand that migrants at the Mexican border, that there's been a practice of extracting DNA, or at least an experimental practice where some less experienced companies were contracted to do this work by the previous administration. But I do think that the DNA issue is popping up in more and more places in the humanitarian space. So to take children's DNA to find fathers, to take DNA to solve rape cases for international criminal law, et cetera, et cetera. So we need to also think about DNA and have ethical analysis of what this means for our group.
Thank you, Kristen. Francois, you had your finger up a moment ago.
Just 2 points following the comments that were just made. One would be, how could we elaborate a right to participation? Political participation is not on the table since they don't have the right to vote. But for example, in the Convention on the Rights of Children, on the rights of the child, the children have the right to participate in decisions that are of concern to them, even though they don't have the right to vote. So maybe there's something that we could elaborate that would give migrants and refugees a voice in the processes leading to whatever decisions. And second, on the migration voices, the art world, novels, movies, have talked about migration and refugees considerably over the past 20 and 30 years. But it's often stories about migrants, not yet often stories by migrants. And so I think we should, there is an investment to be made in a cultural approach to migration, in the sense that we should allow, first of all, migrant voices, but also encourage narratives about migration in order to change the perceptions. Perceptions will not be changed, and I'm talking about, emotional perceptions here, will not be changed by the 14 principles or the Global Compact. We need other ways of touching people. And that comes with culturally adapted media. And I think films and novels are part of that, but there would be other ways. And we need to have a strategy about that. So maybe these 2 points do not, cannot be connected directly to the 14 principles 0.2, but is it something we should keep in mind? We won't change perceptions without being culturally relevant to the people who are opposed to migration, or who think that migrants should be, differentiated and discriminated.
I think that's a good point, in fact. I think there's a basis, perhaps, for taking the 14 principles out beyond the present cadre of signatories to the wider audience that you just indicated. And it's simple enough, the language is straightforward enough to be saleable, if you like, to the non-lawyer. That's one thing, we could maybe put it out to a wider audience. The second thing is, well, what about those who did sign? What are they going to do with it? What have they done with it? Have they done anything? Why not contact them and find out what they have done?
Thanks, Francois. Thanks, Guy. Monette.
No, I just wanted to reiterate that I love the idea of capturing some of the good practices and the lessons learned, both on this issue of participation and meaningful participation. And I think that there's something to be learned, from other movements, from, HIV and other areas where I think meaningful participation has been achieved in a more constructive way, and, extrapolate some of those lessons to what it means to really shape policy and assume power and how movements are framed. But I also think, there's an opportunity here with this pandemic, and I'm always struggling with the glass is half full, the glass is half empty. We have seen some really positive approaches on the part of some governments extending the right to health to undocumented populations and to asylum seekers. And I would like us to capture that in whatever is the next iteration of the 14 principles, and use it as a vehicle for for really, talking about how it is possible to do this in a way that is beneficial to our entire population, and to move forward the conversation around universal health coverage, which had been sort of bumbling along before the pandemic. But I think there's an opportunity here to show why it's important and to draw on the lessons learned there. The other area where I really think the principles could be looked at again is the role of the private sector. That's not to say that we need a new principle, it's actually woven into all of them, but the duty of the state to regulate, to intervene, to monitor and surveil what the private sector is doing and how that impacts on human rights. And whether it's directly in the medical sphere, or whether it's in surveillance and the use of digital technologies and vaccine passports. I mean, the private sector is deeply implicated. And of course, we've talked about big pharma as well. So I think that the next iteration of the principles should draw some of those issues out and thinking about what states' obligations are.
Thank you so much, Monette. I want to flag to roundtable participants a number of interventions and questions that have come up in the chat here. We have probably time for one last set of exchanges, and notice we have a question about, in this time of identity politics, whether being a refugee is an identity that creates a basis for solidarity, or perhaps another way to put it is, to what extent can we contribute to crafting a politics that facilitates migrant and refugee identity being a source of solidarity. There's a question about the sort of, the long-term consequences and opportunities to unravel the destination-based or region country-based sort of naming of variants. How do we address the long-term impact that might have, particularly on some corridors of migration? For example, the example given of migrant workers from India and Bangladesh. Have a question about the engagement of refugee rights movements in the People's Campaign globally, and the scope for coordination there, and then an exchange about the dangers and challenges of engaging migrants, avoiding tokenism, but the opportunity and importance of doing that. And then Monette's just underscored the meaning of the sharing of good practices on participation. I just want to throw that set out for one last round, and then Monette will take us to conclusion here. I might also, I suppose, throw out this question of the utility of the regions. I think the Inter-American Commission has been active in developing a set of principles on the rights of migrants sort of before COVID. Of course, the African human rights system similarly has been at the vanguard of the development of norms historically, and I think our discussion of the compacts earlier raises this question of whether some of the advancement of these norms and the utility of these norms might come through more local and regional advocacy for the use of things like the 14 principles or principles on the rights of migrants.
Maybe one point to add to Monette's list of what governments should do, which is something which is already in the 14 principles, but governments are not really keen to do that, is simply apply labor law and force companies to apply labor law. I mean, labor inspections all over the world, including in Canada, are a failure in terms of protecting migrants' labor rights. And I'm convinced that if labor law was better applied, there could be there would be health benefits, and there will be a better connection with the healthcare system, etc. But that's something that governments are not keen to do, and certainly the private sector is not either. How can we push for that? We've said it. It's been said by the ILO. It's been said by everyone, except that it's not happening.
I think one of the lessons that we can draw is, I'm just looking closely at the management of migration and refugees worldwide, is that governments are by no means the only player. There are many other players, including private, including business, who need to be brought into the picture, who engage in activities which are questionable, to say the least, whether it's in aerial surveillance, border surveillance, or document control. So I think there is plenty of opportunity to broaden the scope of appeal for the 14 principles. On long-term impact on migrant workers generally. I think there is much to be said for what Francois has just mentioned, which is the application of labor law. If that were done in the Gulf, amongst other places, as well as Canada, of course, and indeed as Australia, then a lot would be done for the health of the nation, the health of migrants, the health of refugees as well. But I think the first thing is that governments are not alone. They are not the sole repository of power in any means. Yes, they have power. They have phenomenal power, but they are not the sole repository of it. We can influence them more particularly. And maybe we can influence them through business. I mean, after a lot of government is downsizing, is privatizing activities which would normally have been carried out by state agencies, is now handed over to private business. I think that's an area where we need to focus our attention for more particularly in the future.
Thank you so much, Guy. Thank you, Francois, for joining us. Thank you, Kristen and Madeline, for jumping in this last roundtable. And thank you, Monette and Alex, for your participation and partnership. It's been a great pleasure to co-host this symposium over the last 3 days. And now we'll turn it to Monette for some final words, and look forward to continuing the discussion. Of course, all of our emails are on the website, so attendees, feel free to engage us on this. It's been wonderful to have your questions, and thank you for that active participation. Monette, thank you.
Wonderful. Thank you so much, Ian. And thank you, Guy, Francois, Kristen, Madeline, and really all of the paper writers and commentators that have made the last 3 days so enriching and challenging. It's been 9 o'clock in the morning here. It's gotten the little brain cells going, but for many of you, it's been midnight. And I know, we really appreciate the commitment to staying with us on these calls over 3 days and to raising the really important questions that I think we have to grapple with going forward as scholars and human rights advocates and people who care about the framework of law as a way in which to respond to this pandemic. So I really am grateful to the writers, to the commentators and the panelists who've made this such an incredible 3 days. I would be remiss if I didn't thank the wonderful team that made this also possible: Jennifer Ostrowski, Jing Lee, and Simon Mack at Columbia, who've handled all of the logistics and made it seamless. Really, it's incredible given how many commentators and speakers, how seamless it has been over the last few days. And I also want to end, I think, by thanking the drafters of the 14 principles. Many of them have been part of this conversation over the last 3 days, but not all. And all of you who've been good enough to sign them, to lend your advocacy to them, to share them with your networks. That really what has made these principles, I think, live and acquire this 14 principles sort of mantra around them. And the more we share them, the more we talk about them, hopefully the more impact they'll have on policy going forward. So thank you to the drafters, thank you to the signers, and thank you to you, our audience. It's been great seeing your names pop up on our list of attendees. I really appreciate the Q&A, and it's been great having you with us over the last 3 days. This isn't the end of the conversation. As Ian mentioned, we have a special issue of Age-Old Talk coming out within the next month and a half. So we will be in touch as some of these papers are collected, some of these commentaries are collected. And as you've all just heard, we're talking about a 2.0 of the 14 principles. So I'm sure we'll be in touch and find ways in which to engage us all going forward. So thank you all. And I hope you all have a good rest of the week. Thank you. And thank you especially to Ian and Alex. Bye-bye, everyone.
Thank you all.